Hey everybody, this is Advocate Lucinda, your empowerment lawyer. Last week I uploaded a video and the subject matter was the two instances when a state prosecutor can lose his or her absolute immunity. And I wanted to continue on this path with criminal law. And I want to talk about grand jury indictments and when they can be challenged. See, that's where it really starts. It starts with the grand jury. But grand jurors participate in misconduct and they are biased, just like the jury members are. And that's something we don't think about. But the purpose of today's video is to alert you on the possibilities of grand jurors being biased, participating in unconstitutional violations, and you need to be aware of that. So let's talk about it and how to challenge a grand juror or a grand jury. So let's get started. Bias, misconduct. And to help us address these issues, we're going to look at case law. In the matter of State versus Murphy, 110 New Jersey, 1988 case, two grand jurors informed prosecutors they were employed by companies that were victims of the defendant's alleged fraud. Instead of notifying the court, the prosecutors instructed the foreman to interview the jurors off the record. The court held that prosecutors must disclose known grand juror bias to the assignment judge, establishing that a failure to do so could result in the dismissal of an indictment. Constitutional violations. Pursuant to Federal Rules of Criminal Procedure 48, the court may dismiss an indictment, information, or complaint if unnecessary delay occurs in presenting a charge to a grand jury. Under the Sixth Amendment in the Speedy Trial Act, an indictment will be dismissed if the government causes unnecessary and highly prejudicial delays in bringing a defendant to trial. Now, of course, if it is a state attorney, then you need to look at the state rules, criminal rules, right? We always say, even if we're dealing with federal law, we still want to look at the state criminal law just in case it is applicable, right? So always do that just to be safe. So let's look at some constitutional violations or acts that constitute constitutional violations. Judges will dismiss indictments outright if the prosecution violates core constitutional boundaries or statutory limits. If the defense proves that the government waited too long to bring charges under the applicable legal time limits, the court is legally required to dismiss the case. If a defendant can show clear evidence that the government brought charges as direct retaliation for exercising a legal right, such as appealing a previous immigration or civil ruling, courts will dismiss the case on due process grounds. Another area is discrimination. In the matter of Campbell versus Louisiana, 523 U.S. 932 1998 case, Campbell, a white man, was indicted for second-degree murder by a grand jury in Evangeline Parish, Louisiana. Campbell moved to quash the indictment by citing a long history of racial discrimination in the selection of grand jury forepersons in Evangeline Parish. No African American had served as a foreperson for the past 16 years, despite the fact 20% of the registered voters were black. Campbell claimed such practices violated his 14th Amendment equal protection and due process rights. The court continued. The trial judge denied Campbell's challenge, holding that he lacked standing as a white man complaining about the exclusion of African Americans from serving as forepersons. The Louisiana Court of Appeal overruled the trial judge and decided Campbell had standing. Louisiana Supreme Court reversed the Court of Appeal. Campbell filed a petition for a writ of certiorari to the United States Supreme Court. The court accepted his writ. And the issue was, does the exclusion of other races other than the defendants violate the due process clause of the 14th Amendment? And the court said yes. In a unanimous opinion written by Justice Anthony Kennedy, held that a defendant has standing to litigate whether his conviction was procured by means or procedures which contravene due process. A white defendant could assert the right of the grand jury to be free of discrimination because racial discrimination in jury selection casts doubt on the integrity of the entire trial process. Another area, legal sufficiency. In the matter of Russell versus United States, 369 U.S. 749, a 1962 case, 6 individuals were indicted and convicted for refusing to answer pertinent questions before a grand jury. Each of the individuals moved to quash the conviction because they were not told what the subject of the inquiry was. That's important, isn't it? So had no basis, they argued, for determining what questions were pertinent. The U.S. Court of Appeals for the District of Columbia affirmed the convictions. Petitioners filed a writ of certiorari to the United States Supreme Court. The court accepted their writ. And the issue was, does a grand jury have to identify the subject of their inquiry when indicting an individual for refusing to answer pertinent questions? And the court said yes. Justice Potter Stewart wrote for the majority, reversing the lower court's judgment. The Supreme Court held that the convictions could not stand because the grand jury failed to identify the subject of the inquiry at the time the individuals refused to answer questions. So let's look at some other legal sufficiency issues. The wording and legal construction of the indictment itself. A court will dismiss an indictment if it fails to state an offense or lacks necessary elements. Failure to allege a crime. If the government's written charges even taken as entirely true, do not describe an actual violation of federal or state law, the court will dismiss it. Lack of specificity. The indictment must provide enough factual detail to give the defendant fair notice of the charges and to protect them from double jeopardy being tried twice for the same offense. Procedural defects. In the matter of United States versus Mechanic 47-5, U.S. 66, 1986 case, this landmark U.S. Supreme Court case involved a violation of Federal Rules of Criminal Procedure 6D because two government witnesses testified simultaneously before the grand jury. While not individual juror misconduct, it is the leading case on grand jury procedural defects. However, the court ruled that the subsequent petit jury guilty verdict rendered the grand jury error harmless. Structural defects. In the matter of Vasquez versus Hillary, 474 U.S. 254, 1986 case, Hillary, a black man, was indicted for murder by a grand jury in Kings County, California. He was convicted. He appealed his conviction, arguing that the county had systematically and intentionally excluded blacks from serving on its grand juries. Reaching the United States Supreme Court, a majority overturned his conviction. Justice Thurgood Marshall explained why discrimination at the indictment stage leaves a permanent, irreparable taint. He stated discrimination in selecting jurors does not just affect the evidence at trial, it undermines the structural integrity of the criminal tribunal itself. And voluntary dismissal by the government. Pursuant to Federal Rules of Criminal Procedure 48A, the government itself can request to dismiss its own indictment, leave of court. This occurs if the prosecution realizes its evidence is flawed, a key witness becomes unavailable, or overarching Department of Justice policies change and require dropping the case. So let's talk about the challenge for biasness. Pursuant to Federal Rules of Criminal Procedure 6B, a defendant may file a motion to dismiss the indictment based on individual juror bias or lack of qualifications. So let's look at how the challenge works. The mechanism. The legal tool used to contest a grand jury's participation is called a challenge to the poll. The evidence. To succeed, the defendant must demonstrate actual bias, a proven personal vendetta, for example, explicit prejudice, or a conflict of interest, for example, rather than just an assumption of bias. Timing. Under most criminal procedure rules, such as the Federal Rules of Criminal Procedure, the challenge must be filed before the indictment is formally issued or immediately upon arraignment. Pre-indictment challenge. In jurisdictions like the federal court system, the defense can formally object to or challenge an individual grand juror if they are legally unqualified or biased before the grand jury votes to indict. post-indictment motion. If the bias is discovered after the indictment is returned, a defendant can file a motion to dismiss the indictment. The standard of proof. To successfully challenge the indictment, you generally need to prove that the individual juror's bias was severe enough to prejudice the grand jury proceedings and that it influenced the true bill. Timing. Under most criminal procedure rules, such as the Federal Rules of Criminal Procedure, the challenge must be filed before the indictment is formally issued or immediately upon arraignment. Challenge versus impeachment. Challenges to the composition of a grand jury must be raised under Federal Rule of Criminal Procedure 6, while attempts to impeach an indictment using juror testimony are restricted by Federal Rules of Evidence 606B. And let me say again that for state cases, of course, you want to look at the state criminal law rules and procedures, okay? So I trust this was helpful to you, those of you who are fighting your indictment, those of you who are, some have local counsel to assist and some are going pro se. Either way, I want you to have this information to get a chance to get justice, okay? I'm Advocate Lucinda, and as always, be empowered. We'll see you next time. Take care.